Yes, so now that discovery is over in the Lively versus Wayfarer case, all of the potential evidence both sides have. So they've asked each other questions that have been answered. They've asked each other for documents. They've asked each other for files, electronic files, recordings, videos, everything. So everything that one could ask for, they have asked for from each other that could relate to the claims and defenses in this case. And they have them all. Both sides have everything that's been produced. There could be some evidence or some potential evidence that the parties have that they obtained through third parties, for example, but that would have also been turned over to the other side. So if they've third party subpoenaed or subpoenaed third parties for some evidence and obtained it, if they plan to use that, they would have had to turn it over to the other side so the other side had it. So in a nutshell, both sides have everything. They have the universe of potential evidence. Now it's just a matter of each side going through all of the pieces of potential evidence and choosing the pieces that they think support their claims and defenses and using them in the motion for summary judgment or to oppose the motion for summary judgment, and then later the same thing with trial. There is one caveat, however, and that is with respect to something called impeachment evidence. Impeachment evidence is evidence that specifically is used to call out the credibility of a witness. Essentially, you're saying this evidence, jury, proves that this person is lying about something that they're saying. So they're impeaching them with that piece of evidence. That's something that can be held onto and not necessarily turned over. If it's not being used necessarily to prove a claim or defense, it could be held onto so that during a trial, if a statement is made and the evidence contradicts the witness's statement, then the party can show that piece of evidence and say, wait a minute, you're lying about this because I have some proof that shows that you are. So that evidence doesn't have to be turned over during the discovery process necessarily, unless, like I said, it's going to be used for the claims or defenses. This little body of evidence makes up a pretty small portion of what you might see in a trial. It's maybe one or two things that could be used to impeach someone, and it only becomes relevant when you're trying to impeach someone's testimony. But in answer to your question, all the other evidence is mandatory disclosed to the other side. So any evidence that you plan to use to prove your case has to have been turned over to the other side by this point in the process. So by trial, both sides know exactly what evidence they're going to use to prove their case.